Hi, this is Estates and Trusts online module about powers of appointment. This is our second one. You should watch the other one first. This one is mostly about Beals versus State Street Bank and Trust Company. Okay, and in this we explore exercise of a power of appointment, particularly a testamentary power of appointment. We identify some rules of construction regarding exercise of a power of appointment through a will. And we will be describing a context in which the distinction between general and non-general powers of appointment really makes a difference. So how does one exercise a testamentary power of appointment? In Beals versus State Street Bank and Trust, that's going to be the crucial question. There's the bank. Now, Arthur Honeywell is the guy who created the trust here. We introduced him at the very end of the last video. He went to Harvard in the 1860s, and according to a Harvard alumni book or something that I found online, it says, as a student, he did not aim for or attain noticeable rank. However, he was apparently good at baseball and rowing, and did well in his family's banking business. Now, his father was interesting. His father is Horatio Hollis Honeywell, and he married a girl whose last name was Wells. He was very successful financially, but he also had a passion for gardening and horticulture, and he built a fabulous estate, which he called Wellesley for her family. He's also attributed with bringing rhododendrons to New England. And if you've ever been in New England in the spring, you know that azaleas and rhododendrons are absolutely spectacular. Anyway, back to Arthur. Arthur created a trust. And the residue of his estate went to the trust, and the terms were income to wife for her life, and then the income to daughter for her life, and there were trusts for the various kids. The remainder to be paid and disposed of as she may direct and appoint by her last will and testament duly probated. Okay, so this is a power of appointment that he's giving to his daughter, and it is a testamentary power of appointment. She can only exercise it through her will. It's also a general power of appointment. There's no limitations on who she can appoint to, so that would include herself, her estate, her creditors, or creditors of her estate. Actually, since this is a testamentary power of appointment, it's estate or creditors. Those are the key things. So it's a general power of appointment. Now, in 1944, Isabella partially released her power with language that said that she would be able to exercise it only in favor of one or more of the descendants me surviving of Arthur Honeywell. That kind of sounds like Yoda speak. Aside from that, she didn't do anything with her power. And when she died, her will did not explicitly exercise the power of appointment over Arthur's trust. It did have a residuary clause, which said that the rest, residue, and remainder of my property should go to the issue per stirpes of her sister Margaret Blake, who had predeceased her. So the question is, does that residuary clause, which tries to dispose of everything else, does that exercise the power of appointment in favor of Martha's issue? And there are some rules that we can maybe bring to bear. There's really not very much in the will itself to help us. So in Massachusetts, a general residuary clause does not exercise a special power of appointment, but does exercise a general power of appointment. In New York, on the other hand, where Isabella was living when she died, a special power of appointment is exercised by a residuary clause that disposes of all of the testator's estate. So if we use New York law where she was living, then clearly this power is exercised. If we use Massachusetts law, which is where the trust was located, because it's where her father was living when he executed his will and created all of this, if we use Massachusetts law, then their presumption is not exercised. Okay, So the court here says, well, the usual thing is that the jurisdiction of trust administration is the one that counts. That's usually the donor's domicile, and that would be Massachusetts. So we're going to use Massachusetts law. All right, well, maybe we can argue that the will did exercise the power. Now, the power is not mentioned in her will, so no, she did not explicitly exercise it. There's just no way to torture this language enough to get there. Notice the footnotes on page 544. One of them gives you the residuary clause and the other gives you the two rules of construction from the two different states. But in the residuary clause, you'll notice that she does mention a power of appointment under her husband's will. It says, if I have one, I exercise it. But she doesn't mention this one. So our rule is, and this is Massachusetts now, because that's what we've decided on, a general residuary clause exercises a general power of appointment. Okay, that's useful to know. But does it get us there here? Well, this power started out as a general power, but then she partially released it in 1944 so that it was non-general when she died. Now, that's a distinction that's really critical for tax purposes. For tax purposes, if she had a general power of appointment, we include all of the trust property in her estate. So by relinquishing her general power of appointment, she got a lot of value out of her estate for estate tax purposes. The court says, surprise, we're going to treat this like a general power. Even though it's not general when she dies, it started out that way. And we think that she exercised dominion over it, treated the property like it was hers when she released part of it. That's kind of a surprising holding, but think back to the last set of materials. Release is kind of like exercise in favor of the trust taker in default. So maybe she partly exercised it when she released part of it, and this just exercises the rest. Maybe that's how the court's seeing this. In any case, the court says we should apply the presumption of exercise now. Now, it's not clear to me whether they're making a blanket rule that any time there was a general power and somebody partially released it, we should treat that as a general power for purposes of construing a residuary clause in a will. But that seems to be what they're saying. Some people think this analysis is a little bit contorted. So I'm curious to know what you think. And also, this is a question from the notes in your book. What if instead of executing a will, she had created an inter vivos trust and transferred all of her property to it? And it had a residuary clause much like this one that left all of the rest, residue, and remainder to the issue of her sister Margaret. Should we treat a residuary clause in a trust the same way we treat a residuary clause in a will? Should it be presumed to exercise a general power of appointment and or a special power of appointment? Go ahead and post an answer to that on the discussion board. We haven't had a discussion board question for a while, so here's one. And what do we take away from all of this? Well, for one thing, choice of law really matters. I mean, here was something where the two states kind of had different rules. So the trust can specify which law applies to the trust. A will can specify which law should apply to a will, but in this case, because the trust creates the power of appointment, if the trust had said power of appointment exercised under the law of Massachusetts, that would have solved us a little bit of the litigation. Would have saved us from a little bit of the litigation. Another point to take away from this, evidently after Isabella exercised her right or released part of her power in 1944, she must have forgotten about it, because the will does specifically mention a power of appointment under her husband's will, but it doesn't mention this one. So, the only possible conclusion is, is that the drafting attorney did not know about this one. Because you can certainly imagine that if they would have mentioned one, they would mention both of them. Clients forget. Now, how do we help clients remember things like this? You know, you might kind of have to go through the list of wealthy relatives who've died in their lifetime and say, are you sure, blah, 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 you know, and maybe she would have mentioned something about this. You know, it's also possible and quite likely that her drafting attorney knew about Gordon Dexter's will because the attorney did both of their wills. Not at all unusual for married couples to be advised by the same attorney. Now, there are some pitfalls there. Sometimes married couples with wealth don't actually have the same interests, and so there are some professional responsibility questions that can come up. But that's not our problem right now. The point is just that clients don't always remember all of the things that might have an effect on the disposition of their estate. And then finally, you know, either this power was exercised or it wasn't, but we don't have anything to tell us in the will itself. So we need a presumption. I mean, we need a presumption that says a residuary clause does or does not exercise a power of appointment. And so we've looked for presumptions and default rules in other contexts. This is just a reminder that that's where we have to go if we don't have anything specific. Of course, we can make it specific. And then the prevailing winds seem to say that a general residuary clause can exercise a power of appointment. So you do know that now. Okay, and that's a rhododendron, in case you weren't clear. And this is, get me out of here. This is part of the Honeywell estate. Old Horatio Hollis Honeywell loved gardening. And that's the topiary garden. Thanks for watching.